We thank you so much. Thank you for watching uh, this channel, Law School Made Easy at Law School Made Easy 256. We ask you to always subscribe and follow all our videos. But this particular video is dedicated to the students, first year students of UCU. At the Law School of UCU, we welcome you to the Law School. Thank you for choosing law. Law is the best course, and we are certainly sure and aware that you shall achieve all your dreams. In a special way, allow me send these greetings to a colleague at Haile Bright. Is one of the coordinators of one of the law streams at UCU. Thank you for contacting us, and as requested for order in council, this is the video. But we urge you at Haile and the team, subscribe to follow more of all these videos. We shall upload all the videos you need as you progress in your studies at the law school. Let us enter into order in council. Order in council. We all have to remember that in 1900, there was a signing of the Buganda Agreement. An agreement was signed between Buganda and the British government, and that agreement is one form of establishment of the British rule in the country. That the British wanted to establish their rule in Buganda. Remember, we had become a colony. Those of you remember the history of scramble and partition. When we were scrambled and partitioned, British took us over at Berlin. So if you remember that history, so we are now a British protectorate. Now, to establish their rule, they signed with Buganda simply because Buganda was one of the strongest, give Uganda its location in the heart of the capital, its central location, the strategic location. So they had to sign with Buganda an agreement. But after signing an agreement with Buganda, they wanted to formalize their rule in the whole protectorate. Remember, this is Buganda agreement, but now they want to formalize their rule, and that is why in 1902 they brought what we call the 1902 Order in Council. Order in council means the formalization of the British rule, the formalization of the British rule in the protectorate. They wanted to formalize their rule. But one thing you must note about this paper, constitutional history. The essence of this paper, we are tracing our history. Where did we come from as Uganda? Where did we come from? Where did we pick an idea of, say, having a constitution? So, as you discuss these concepts of order in council, try to relate them with the current constitution. Is it possible that the articles we have in our constitution, they originated from the order in council, that we must have picked some articles from order in council and now put them into our constitution? So we try to understand the meaning of these articles one by one, but as you understand them, you conclude by relating it to the constitution. Is it possible we picked this idea here? Is it possible this idea was picked from here? Like that, like that, like that. So let's go into the first article of the order in council, which suggests that there shall be the demarcation of the boundaries, and these boundaries were now in two regions and were divided into five regions. One was the Western Province, the Rudolph Province, the Nile Province, the Central Province, and the Buganda region as a whole. Now, these five regions, the reason why the British divided these was very simple: for easy administration and for extending their jurisdiction to other areas of the protectorate. Remember, in the Buganda Agreement, they only divided the demarcation of Buganda alone, but now they have moved far as east, west, central, Rudolph, and other areas, Nairo region. So we are saying that if the SS was to divide and for easy administration, is it possible that our article 179, 177, and 178, is it possible that they are a manifestation of the order in council, article 1? Is it possible that we picked this from here and then we have it in our constitution today? Yes, it is possible, because if you read article 177, creation of districts, and 179, creation of boundaries of local governments. So we are saying, is it possible that the idea of demarcation of boundaries for easy administration. Is it possible that where the framers who made our constitution in 1995 were thinking about the easy administration of this country, they thought about that bit of the Order in Council, and they got those articles and now put it into our constitution. So you relate that Article 1 of the Order in Council with Article 177, 178, and 179 of the Constitution. Let's go to the next article of Order in Council, where they say that the Order in Council shall create a commissioner who shall be the head of the protectorate. That there was a desire to have a commissioner as the head of the protectorate to run the day-to-day activities. Everybody to report to that person. Is want to understand how the protectorate is moving. Now we are saying, is it possible that Article 98 of the Constitution that provides for the office of the President as the head of the Republic of Uganda, could it be possible that we picked this idea from that Article 4 of the Order in Council, and now we have it in our Constitution? So we are relating the Commissioner with the President in Article 98 of the Constitution. Let's go to another one about land. They are saying that Crown land in Article 7(5), that Crown land shall be owned by the government, that all government parastatals, government hospitals shall be on this Crown land. Remember, in the Uganda argument, could be Article 12, land was divided into Mairo and the Crown, but now they are saying in the Order in Council, Crown land is land for the government, including the minerals and mines were all to be a property of government. So we are saying this idea of division of land, dividing land, this one is taking this, one is taking this, the one we have in Article 237. Is it possible that Article 237 originated from this Order in Council, the land article? Is it possible? That's the question you ask yourself. And then when they talk of government owning the minerals and mines, is it possible that those minerals and mines, Article 44, Article 244 of the Constitution, Article 244 of the Constitution, is it possible that Article 244 originated from that clause of the Order in Council? Yes, it is possible, because if you read Article 244, it clearly says that government shall own all the minerals below. Okay, so that is how, colleague, you try to relate the articles under the council. You relate them with the Constitution. What looks alike? What could we have picked from the Order in the Council, and now we have it in our Constitution. Let's go to the next one that says that the commissioner shall be in charge of revenue, that shall collect all the revenues that are needed to run the protectorate. That the commissioner is the one supposed to collect all the revenues for the smooth running of the protectorate. That all monies, remember in the Uganda agreement, that all monies collected in the Uganda agreement would be handed over to the central government for them to plan for the protectorate. Now they are saying that the commissioner shall be in charge of running that. So we are saying, is it possible that Article 153 and 152 that talks about revenue and the consolidated fund, is it possible that those articles originated from this clause of the Order in Council? So that is how you try to relate most of these articles. Let's go to the one of justice. That the commissioner, that there shall be a court that shall listen to all matters, white and black, black and black, white and white, all matters shall be handled by this court, and that court shall be called Her Majesty's Court, High Court of Uganda. Her Majesty's High Court of Uganda. That where we have discrepancies, where we have issues, there shall be a court, and that court shall be called Her Majesty's High Court of Uganda. So we are saying that, is it possible that this judicial system we have today, Article 126 of the Constitution, that creates the court of judicature, is it possible that it originated from this? Is it possible that we got it from this clause 10 of the Ordinary Council, which says that there shall be Her Majesty's High Court of Uganda to handle all disputes. To handle all disputes. So we are saying that that is how you try to relate these articles. Let's go to section 15, that we call the reception clause. In this clause, what we call the reception clause, 11th August 1902, this is when we received all the law, that the commissioner was tasked to bring all the law, the common law, the England law, to operate, the common law to operate in this country. And we call it the reception clause, which happened on the 11th of August 1902. And in the reception clause, we received the Evidence Act, we received the Contract Act, we received the Penal Code, and very many other laws. Now, the receiving of these laws, up to now, they are still operation. The other day, remember, the Contracts Act was repealed, and now we have Contracts Act 2010. So you relate this one, the Penal Code, with the Penal Code we have. What we got then, and then what we have now, and then the Evidence Act we have, the Contracts Act, and very many other acts. So that is the reception clause. Then further, in clause 2 of the reception clause, we have the repugnance clause, and this one is the most important that students want. The repugnance clause. That while we received the British laws, we are now bound to use some of these British laws. But they were saying that some of our cultures were repugnant. The fact that they were inconsistent, repugnant can mean inconsistent. So because they were inconsistent, they devised the means of how to use them. That only those who passed the objective test of morality, consciousness, equality, those are the cultures that would be taken as being valid. So those ones which did not pass the test were considered to be repugnant. So there we go to the creation of the doctrines of consciousness, morality, and equality. That they looked at our culture as being barbaric. So, and most of our, and for them in their mind, we were saying that some of these cultures are very barbaric, much as even the common law had outlived its usefulness. Some of the common law were too ancient to be applied. They now said, let us use the objective test of consciousness, morality, and equality. That they looked at a culture which passed the test of equality, morality, that it does not subject people to inhuman treatment, then that culture was considered to be the right one to follow. We have so many cases. Let's take an example of a case of Ara versus Amkeyo. In the Amkeyo case, this man was charged of theft. But being charged of theft, the person who was supposed to give evidence against him was his wife. But you know, in the law, your spouse is not supposed to give evidence against you. So the courts were saying that this woman, Sir Hamilton, that this woman was okay to give evidence against this man, because what in Africa we consider to be marriage was not marriage, was just a mere wife purchase. Why are they calling our marriage a mere wife purchase? They are saying that in our marriage in Africa, we take women as chattel, as property. The idea of bride price does not give a woman the contracting right. She cannot contract well because everything is decided on her behalf. So you don't get her consent, her free will. Those of you who are doing contract, we know that section 11 and section 10 says that for a valid contract, there must be free consent of that somebody to enter into a contract. So they are saying in the marriage of Africans, there is no free consent. So our marriage is considered as a wife purchase. So there is no, it is not what would be called an ideal marriage. So therefore they say that the wife was liable to give evidence against his man, and indeed the wife gave evidence and MK was charged. So that is repugnance. So they are saying that our culture was repugnant. Remember, the point here to take is very simple. A wife is not supposed to give evidence against his spouse. But in this case, a wife was accepted because they believed our culture was ancient, was very barbaric. And the wife, in this case, for us, what we call the marriage, to them, it was not marriage. I implore everybody to go and read that case. That case, you see that it defines Section 3 of the Indian of the Indian Evidence Act. Section 3 defines what marriage is supposed to be. So I implore everybody, that case is in the law report. Please go to the library, get the law report, and read the entire case of Amkeyo. But as read Amkeyo, another locus classicus case here is Mwenge Migadde, Uganda versus Ally versus Uganda, and very many other cases. We have a case of Chisunda and Chirimo, one being Chisunda and Chirimo. Let's talk about Chisunda and Chirimo. In Chisunda and Chirimo, a man called Manga was a taxi operator that used to get taxis VAT from people. So he took money and he never gave a receipt to the person he took the money from. So when he took the 20 shillings, when he took it, this man charged him. So Manga was charged. Manga, on conviction, this man went and picked the property of the father. They are punishing the father for the crime committed by a son. So the British are saying that is barbaric, that is ancient. You cannot punish the father who is there. You go and you sell his head of cattle simply because his son committed a crime and he was convicted. So in that case, it is the father, Chisunda, that was arguing against Chirimo that you cannot take my property. I was not there when you guys did whatever you did. So I implore students to go and read the case of Chirimo and Chisunda as one of the leading cases on the repugnance clauses. Let's go to the final one, in where the commissioner had the powers to import, detain, or throw away anybody that was resistant to the rule in the protectorate. The commissioner was given powers that for anybody who brought an issue, it was very easy for you to be deported. So the deportation ordinances were all passed, and it was only, but before, sorry, I forgot to connect the repugnance clause. Allow me to connect it to the Constitution. So while handling the repugnance clause, look at Article 2 of the Constitution. That says that any law or custom which is inconsistent with the provisions of the Constitution shall be to the level of it's inconsistent, declared null and void. So we are saying that it is the Constitution which is supreme law. Any law which is inconsistent shall be considered to be void and null. So that is how you relate that repugnance clause with Article 2 of the Constitution. Let's go to the deportation ordinance, that the commissioner had the powers to deport anybody who was against the British rule in the protectorate without inquiry. And the rule there was that there was no appeal that can be done, that nobody would do an appeal if you were deported. All those powers were given to the commissioner. So we are saying, is it possible that the whole Article 28 of fair hearing, that we must have got it from this barbaric clause, which says that if you oppose, you are deported and there is no appeal made. But you see that all our rights have been protected, enshrined in Chapter 4 of the Constitution, and particularly Chapter 23, Article 23 and Article 28. I implore you to read Article 23 and Article 28 that protects us from all any inhuman treatment. So that is how you handle the element. That is how you handle the element of order in council. And then when we come, you see students, you have requested for something to do with contract. We shall do contract, and then later we shall continue with order in council 1920. That has been order in council 1902. Hope this information helps you. go through it, but don't forget to always subscribe to our channel, Law School Made Easy, at Law School Made Easy 256. Thank you so much. See you next time.